our webinar today in relation to preparing for the sale or acquisition of a business, the legal considerations. Today's webinar is going to be very short, so if you have any questions that we haven't answered during the process of the webinar, please don't hesitate to get in contact with us. We'll send you some information about how you can contact us after the webinar. And also remember that you can add questions or comments throughout the webinar in the bottom right hand of the chat session above the button Send Message. So, my name's Joanna Oakey, and today I'm talking about, as I said, preparing for a sale or acquisition. Selling a business can be likened in many ways to selling a house, and today we're going to talk about 4 areas in relation to selling a business, like selling a house, the process that you'll go through, planning that's required, a risk and opportunity, comments and implementation. When I say that your business or selling a business is a bit like selling a house, I guess what I really mean is that your house might be looking great on the outside, but if a prospective purchaser walks in the front door and finds holes in the floors and gets a pest and building inspection that shows termite action in the walls, your sale price and your pool of buyers is going to be severely depleted. And so it is with the sale of business. You might be able to negotiate a great headline commercial deal, but the real question is what a prospective purchaser is going to find when they bring their accountants and their lawyers in. Will your business make it through the due diligence phase without taking a hit to the figure you had in mind and to the kind of terms you have to agree as part of the deal? Just the same as you might mow the lawn and paint the walls before you put your house on the market, when you're thinking of a possible future sale of your business, you really must ensure that you start off by thinking of the investor. How is a prospective purchaser going to assess value in your business? If you're not on top of this question well in advance of thinking about a sale, you're creating the environment of simply a price-driven deal. But if you can tick all of the boxes in due diligence and about value, then you have the environment where a buyer can hit the ground running. So first, I really just wanted to talk about the process. So here's a bit of a diagram of the outline of the process as many people see it. Starting off with starting the search, finding a broker, who then helps you to find a buyer or target, signing a non-disclosure agreement or NDA, or also called confidentiality agreements, and providing and reviewing initial figures. Then after all of that, we generally come to the commercial deal. So the buyer and the seller negotiate a deal, and then generally come to the point when they've agreed the commercial terms. They sign a document, often called an MOU, a Memorandum of Understanding, or a Heads of Agreement, or some other short commercial terms document that set out the commercial deal as agreed. And then often due diligence will start. Now this is often the point when an SPA or a sale and purchase agreement, whether it's for the business or the shares or just the assets, is negotiated. So we're negotiating the document, finalising the document, and then finally, after DD has finished, we're getting to execution of the documents where all parties are signing. And then the next phase is called completion. We transfer contracts out of the business, if it's a business sale environment, or do the other things that are required to ensure that the business or shares transfer over, and we hand over money. And then finally we have the last ongoing matters where we deal with earnouts, so money or deferred payments, so money that's paid after the completion date, and the management of ongoing risks. So the biggest impact in relation to, if you're the seller of a business, how much you'll take away in your pocket, money I'm talking about here, and how smoothly this process will occur, will come down to how your business looks when you're showing the inside of your business. both through the initial figures and through the due diligence process. For those of you who don't know, due diligence is when a prospective buyer goes through all the financial and legal implications of the business to analyse where there might be risk in the business. But many buyers and sellers involve their legal advisors in the process at this agreement phase, which you can see really occurs right in the middle of the process. And this, as I'll explain today, is oftentimes way too late in the process, and it really can seriously impact the way that the sale happens and the ultimate outcome for both the seller and the buyer. I want to use an example here of a client that I've worked with in the past, because I think it demonstrates a lot of practical points that I'm trying to make today. My client, who we'll call Barry for today's purposes, had a mining consultancy firm. Now, I was introduced to him at the agreement phase, which isn't unusual. Quite often, if I'm introduced to clients in a sale environment, it might often be at this phase. So, in this particular deal, the initial figures had already been provided, the deal had been negotiated, the commercial terms of the deal were already agreed and signed, and due diligence had already started. So the result was that Barry ended up more than $3 million out of pocket because he'd left legal advice way too late. His business had holes that were picked up by the investor during due diligence. His business structure coming into the sale was completely wrong, and the investor ended up beating down the price, forcing him into a sales structure that meant his tax bill was double what it should have been. That's right, double. And because of the risks in his business, he had to sign warranties that lasted a long time after the date of the sale. So his price ended up being a lot lower, his tax massively higher, and his ongoing risk far greater than if we had gotten into this sale process before he'd started the process, rather than when he was halfway through. On the flip side, I guess some of that information and warning relates to people who are sellers. But on the flip side, if you're an investor or you're a buyer, then here is where you need to be absolutely on the ball. You need to be able to identify the risks in a business and either use it to leverage a better price or to get the hell out of there and get into a better deal if you're finding risks. Either way, it's absolutely imperative for you to understand the elements that are important in a business being offered for sale, so that if you're the seller, you know about these risks before you allow a potential buyer through the front door, and if you're a potential buyer, so that you understand what it is that you're really looking for in a business before you hand over your cash. So, now that we've talked about the process, let's move on to planning. And the areas of planning that you really need to think about. Obviously, there's lots of areas, but I've tried to simplify it as much as possible in this very short space of time. The structure of ownership, the methods of sale, and getting your house in order. So if we start first with the structure of ownership, I guess I really just want to start out by making it really clear that structure can be worth millions of dollars to you in your pocket at the end of the day. So the question for you is, if you're looking to sell, are you absolutely sure that your current structure will get you the best price in your pocket? I've seen many sellers lose millions, and I'm not joking when I say millions, because they came into a sale with an inappropriate structure. I've also seen lots of deals fall over, and some that couldn't even get to the starting blocks because their structure was too complicated. Recent figures show that in the last 3 months, almost 50% of business sales in New South Wales, in the range of the $1 to $5 million sale range, have been to overseas investors. Overseas investors simply don't like some structures that businesses sometimes use. So if you don't want to cut out half your market, then you really must consider your structure from the start. If you want to be able to access small business concessions, you need to make sure that your structure is such that you'll be able to access them. Sometimes the way your structure is set up makes it impossible. If your buyer might be an overseas investor, or you just don't want to rule out that market of overseas investors, make sure you aren't stuck in an overly complicated structure. So start off by thinking about who your buyer will be and what it is that you want to get out of a sale. Structure is something that ideally should be bedded down years before a sale, so it's really something that you have to be thinking about now, even if you're not thinking about selling this year. In fact, it's the best time right now to be thinking about structure if you're not thinking of selling in the next year or the next 5 or 10 years, so you have enough time to get yourself set up properly. The second area that I wanted to talk about in terms of planning is methods of sale. So we have lots of different potential methods of sale. We have business sale, share sale, asset sale, and all of these have different impacts on how taxation will work for both the buyer and the investor, how much stamp duty will be applicable for the investor, how the mechanics of the sale will actually happen, which is different for each of these different methods of sale, and what kind of warranties the buyer will have to provide into the future or will require the seller to provide after the sale. So you need to understand what methods are possible for your business if you're selling, or the target business if you're investing, and which will result in the best outcome for you. So make sure you understand the methods of sale that are available and which would provide the ultimate outcome for you in terms of all of those different areas I'm talking about. And the third area in terms of planning, and this is particularly for sellers, is getting your house in order. Just like when you're selling a house, an essential consideration when you think of a sale should be, what is the buyer going to be thinking? So your business might look great on the outside, but what will an investor see when they come past the front door? As an investor, on the other hand, you should be thinking about whether the value in the business is locked in and whether there are ongoing risks that you might be buying into. So just like when you're purchasing a house, if there's termites eating away under the surface, then the outside might look fabulous, but obviously you need to do a proper pest inspection that should hopefully reveal the risks that aren't apparent from the outside that are eating away the value, that the seller may not even have been aware of before due diligence. So what are the key areas in a business? I've listed them all here, so it should be fairly easy for you to work out what I think the key areas are. Essentially, I guess we're asking, are the key clients locked in? So is that value in the client pool locked in? Or will they leave once new management takes over? Or is there something else keeping the value locked in for the investor? What liabilities exist in the current client arrangements? So it's interesting when we start looking at client terms and the warranties and indemnities that are provided in client agreements, where we suddenly see risk that a business owner may not have been aware of before. What risk mitigation strategies has the seller actually taken to limit the business's ongoing liability? Are suppliers locked in? Are key employees locked in? Is the business compliant with the employment laws? And this one can be a really big one for organisations that engage contractors. Is IP protected? Could employees take clients? Is location important? If it is, then is it locked in for a long enough period of time after the sale? Is the business compliant with legislation, or could the investor be hit with a claim in the future? For example, a failure to comply with the new privacy legislation because the current owners weren't on top of the new legislation. I just want to pause here by asking a few questions for you to think about. If you're looking at potentially selling in the future, how would you fare in all of these areas that I've got listed if you had to put your business on the market today and have it subjected to the due diligence process? Do you have your major value locked in? So I mean your major clients and your key employees and your key suppliers. Are you fully compliant with the myriad of laws that relate to your business and the myriad of contracts that you're a party to? Do you have the right structure in place to ensure that you're taking away the maximum possible value in your pocket? I know there's lots of questions that I've asked here, but it's far better to ask and know the answers to these questions well before a sale rather than leaving it to the last minute, or worse, until a buyer finds the issues before you do. All right, so moving on to the area of risk and opportunity. And I guess this is really asking the question of what is the risk if you don't have the proper planning in place before you launch into the deal. So the risk is really that you can't find someone to buy your business for the price that you want, or at all, if you're a seller. For both parties, it might be that the deal falls apart during due diligence, which can be really frustrating for everyone, not just obviously the seller, but also for a buyer who thinks, you know, they've made an offer on a business and are about to spend a whole heap of money in investigating a business on the basis of their understanding of the risk elements in the business, only to find during due diligence that there's a hell of a lot more risk than they initially thought was there. Price is obviously a big one. If things are discovered about the business that aren't so flattering, obviously that has a major, or can have a major impact on price. And it can also have an impact on how the price is paid. So this is where deferred payments can often be either now put on the table or increased from where they were previously. So deferred payments being the concept that some of the payments for the business now won't be paid at completion or the time of handover of the business, but paid at some point into the future, and sometimes maybe only if the business moving into the future achieves certain targets. And ongoing risks for both parties after the deal. I guess maybe it's easier if I go back to an example. So I'll head back to my client, Barry, who had 160 contractors. There were issues that were raised because many key staff were contractors and casual and weren't locked in. There are employment law issues that were raised during the due diligence process in the grey area of the use of contractors rather than employees, which is an absolutely murky area for any business. Employment and contracting agreements didn't have non-solicitation clauses to prevent the employees and contractors from taking staff and clients. In auditing the client agreements, the buyer found that the business had provided indemnities that were broader than would be usual, so posed a greater level of risk for the business than was really necessary, and so therefore for the new buyer. There was evidence that the business wasn't in compliance with new legislation like the Privacy Act. And so based on all of these factors, the investor felt the business was far more risky than they initially thought it would be, so they negotiated down the price. No surprises there. But they also said they wouldn't proceed unless Barry provided indemnities, promising to repay money to the investor if the business was sued in the next 7 years or had any issues in relation to any of these other areas that have been raised in the next 7 years. They also forced an earn-out, given the clients weren't locked in, which is not unusual if a buyer or potential buyer finds that issue in a business. But what was the result at the end for our client? Our client ended up getting a lower price. Part of that price wouldn't be in his hands until many years later. And additionally, he had risks that would follow him for the next 7 years. And clearly, it wasn't the clean sale he was hoping for. But the sad thing is, it could all have been avoided if he'd had his house in order well before the sale. So, if you're a seller, think about the investor. How are they going to be assessing value in your business? Otherwise, they'll just create a price-driven deal if you're not on top of it before they are. But if you can tick all of those boxes in due diligence and about value, then they can just hit the ground running, and the commercial deal that you've negotiated is the one that you can continue to run along on. For an investor, on the flip side, it's really extremely important to be able to assess as early as possible what risks there are in the business and whether those risks are something that might bring your investment down in the future. You might be able to negotiate a great price, but if there are risks hiding beneath the surface that could be fatal to the business, will negotiating a cheaper price be enough for you? It's really imperative as an investor to fully understand the business you're buying and to conduct the deal accordingly. So that's it. That's really a very quick, short overview of things to consider in a sale and acquisition process. So my top tips are start early in the process, particularly if you're a seller. Make sure you're organised, you know where the value in your business is, and you've locked that value in. And that you've got your structure right so that you can take away, the best end result in your pocket. Make sure you've got key agreements sorted, and make sure your house is in order. And from a buyer's perspective, you should also be starting early as well, and make sure you understand what you're looking for when you're looking through a business. Make sure you understand the structure that you're purchasing into. Make sure you're confident that you're getting the value in the business that you think you're getting, and that it's locked in through the key agreements with clients, suppliers and staff. And make sure the house is generally in order and that there is an ongoing risk that you're purchasing into. And so that's it. The last thing I'd say is in implementation, if you're looking at a potential future sale or a future acquisition, come to us. We've got a number of resources that we can help you with. We have free ebooks for sellers. Here's a picture on the screen about preparing for the sale of your business. We also have a free consultation to help you get across all of the issues that you need to be considering in getting ready for a sale. And for our clients, we also provide a number of free checklists. For investors and buyers, we have another ebook, a different ebook, a buyer's guide to closing the deal. We have a free consultation in relation to talking about the approach to use once you've found a target business. And once again, we also have free checklists for clients. So if you're interested in any of these, just pop us an email or give us a call on the number or on the email address that you see on the screen, and we will be in contact to organise sending you the free ebooks and organising a free consultation. Thanks a lot for tuning in today. I hope you found this useful and informative, and we have a number of other webinars available if you're interested in other general areas of commercial law. Thanks a lot. Have a great day. Bye.